court now, where the DNA analyst is wrapping up his testimony.
So I had items 2A and 3A. 2A was a swab of tips of fingernail clippings from victim's right hand. Item 3A was swab of tips of fingernail clippings from victim's left hand. Item 3A, PCR procedures for autosomal DNA analysis were not performed on item 3A due to the presence of large amounts of total DNA compared to male-specific Y chromosomal DNA. That is a case, basically, when we do our quant, or when we see how much DNA is there, we can see how much, in situations like this, we can see how much female DNA is present versus how much male DNA is present. And if it's too little, the next processes won't show up the male contributor because there's just too much female DNA. It's kind of like trying to hear your phone ring in a rock concert. It just gets overwhelmed. So at that point, we stopped with that sample.
So you're referring to the clippings of the left hand?
That's correct.
Okay. And so, and for reference, the items that you're dealing with are literally swabs. They're very tiny.
That's right.
All right. And so, did you have the occasion to test the clippings from Christina Parcell's right hand, which is your reference item 2A, to the knowns?
Yes, I did. So for item 5A, or I'm sorry, for item 2A, swab of tips of fingernail clippings from victim's right hand. My findings were...
I'm going to object pursuant to Rule 403. It is our position this has no probative value based on their inability to properly establish chain pursuant to the
Your objection is noted for the record.
Good again. So did
just for the record, I find that Rule 403 is extremely probative and substantially outweighs any other prejudice. But your objection is noted on the record. Thank you.
So I'll refer you back to clippings of the right hand 2A.
Yes.
And compared to our known references there.
So the DNA obtained from item 2A is a mixture of at least two individuals, a major female and a minor male. Assuming Christina Parcell is the major contributor to this mixture based on this being an intimate sample, a match between the minor DNA result of item 2A and the DNA of Zachary Hughes is approximately 825 million times more likely than a coincidental match to a random unrelated individual. Michael Manigault, Bradley Post, Alex Fields, and John Mello are excluded as contributors to the DNA obtained from item 2A.
So did you just tell this jury that Zachary Hughes' DNA is 825 million times more likely than a coincidental match to a random unrelated individual located under Christina Parcell's fingernails?
So what that stat means is it's called a likelihood ratio. And basically, we're looking at two hypotheses as an explanation for the evidence profile that we find in the sample. So for every comparison, and we compared all the people to it, for every comparison, the first hypothesis is that this person's DNA is the best explanation for what we found on the evidence. And the other hypothesis is that it's somebody else in the random unrelated population. And so we're able to do statistics on this. And so it's kind of like sort of a seesaw effect. So when you have, for example, I read an inconclusive one recently, that's where it's kind of balanced, like it's not really tilting one way or another. If it's an exclusion, it means it's tilting toward someone in the random population is the better hypothesis to explain the evidence. And when it tilts the other way, which it did in this case, that's giving strong support for the hypothesis that that person's DNA is the best explanation for the evidence.
So what is the lowest probability standard that you would be permitted to report?
Per our lab policy, the lowest we'll report is a match score of 1,000.
And this one was 825 million?
That's correct.
All right, let's quickly bring back in trial attorney Wendy Patrick. Wendy, I just got to say I love what the prosecutor did there. Some of the information being put forth by this expert, a little difficult to follow, but he followed it up in such a great way, basically restating the question, leading him into another answer, wasn't objected to, but he said, did you just say, did you just tell this jury? Then he said it in more plain English, which was followed by an answer that I thought really clarified it for the jury.
Yeah, I love the way he followed it up. You know, Michael and Ashley, you probably both know this. Questioning, direct examination by a prosecutor of a DNA expert can be very, very tricky. And that's because the language is so different than what we're used to in real life. You notice this expert used the term match several times. That's unusual. Normally, it is a process of exclusion. But one of the other things I always like to do with DNA experts, you heard that this expert used the word septillion earlier. I like to say, tell this jury how many zeros is in a septillion. In other words, whether or not they want to say it exactly like it's a match, it is a match, because that's the only likely and reasonable explanation of the evidence, which of course is what the jury instructions require. So it's interesting that this prosecutor, just to be safe, had the expert rephrase it several different ways to give the jury the understanding that whether or not the expert can actually say this defendant is the source of that DNA, being able to rephrase it 3 different times, that's the way they're going to explain it back in the deliberation room.
Yeah, I just love, Judge, the way, you know, he asked him, what's the lowest number that you can say there's a match? He said 1,000. And in this case, it's 825 million.
Exactly.
So that brought it all home for me.
It did, but I have to tell you, I'm surprised, to your point, that the defense did not object because it just repeated that information for the jury. But let me ask you this, Wendy. I think also, how does a defendant get around, or can he, that his DNA was underneath her fingernails? 31 stab wounds, a lot to the neck, to the head, but the front of the body, the back of the body as well, on the upper body, and then you've got his DNA under her fingernails. I would assume as she may be trying to fight him off.
You know, and you've no doubt seen this in your own courtroom when you were sitting as a judge, where you do have conclusive evidence. And so what happens then? In many cases, it becomes the police on trial. The evidence was compromised. It was a setup. I mean, remember, there was a lot of DNA evidence in the O.J. Simpson case. But we don't have any of that here. And that's one of the things that makes it extremely challenging for the defense. And that's another reason you see they're very calmly perfecting their record, not thinking anything's going to necessarily lead to an acquittal, but perhaps simply making sure they do everything by the book. And I know you've got to imagine that's what the jurors are thinking, although they can't talk about it at this point. They're no doubt thinking the same thing, is where is the catch? Why are we hearing so much evidence about something that seems so conclusive? And again, they're also noticing chain of custody objections. They're taking note of them the same way the judge is. But at the end of the day, you're absolutely right. Whether or not they can come up with the why would somebody do this? It does seem to see the suggesting that whether or not they can come up with a motive, they certainly do have the DNA to back it up.
Yeah, and I think the defense does plan to put on a case. They're either going to call someone who's going to say, yeah, I've seen them together, or they've got to put this guy on the stand to say, look, I was around her at various points during this particular situation. That's how it could have gotten there.
And my
otherwise
DNA was on the bike. Otherwise, I think it's a hard uphill battle for this defense.